wrapping up the bench trial against Illinois' gun and magazine ban, Judge Stephen McGlynn invokes the history of race riots from East St. Louis to Tulsa, Oklahoma, and even highlighting a recent incident in Aurora, Colorado of a transnational gang with high-powered rifles kicking in doors of an apartment building and asking what if these individual victims were armed. Interesting question to wrap up a trial challenging the state's gun and magazine ban. Welcome in. It's Illinois in Focus Daily. I'm Greg Bishop. Be sure to like, subscribe, hit that notification bell. Join us each and every weekday morning as we bring you the latest of what's happening here in Illinois with Illinois in Focus and the Center Square. So again, like, subscribe, and hit that notification bell for America's Talking Network. I was in the East St. Louis federal courtroom each and every day of the trial this week. It started Monday and went all throughout yesterday, Thursday, where it wrapped up with the plaintiffs resting and the defense resting. And then Judge Stephen McGlynn shared some comments. And I do want to go through his comments in particular. But before we do that, let's follow what happened here on X. And if you don't follow me on X, just search Bishop on Air and you can follow that, where you can find the thread from each day of the court hearing this week, Monday, Tuesday, Wednesday, Thursday, with dozens of posts of the best I could do on my phone, trying to distill down some of the things that they're talking about. And if you've never had to do that in rapid succession, well, while it's being discussed in the courtroom, trying to distill it down, a lot of mistypings and misspellings, and I think I got pure competitor mixed up with peer competitor when talking about military opponents. Maybe I slipped on some of the firearms that were being discussed, but ultimately you should get a general idea by looking at that X thread from each day as to what took place in the courtroom. So let's get into it. All right, so we'll actually kind of start with the plaintiffs in their final statements when they wrap things up. So here we go. We got litigants discussing exhibits. They set some time aside for closing arguments. With the plaintiffs, they said the case addresses constitutional question whether commonly owned semi-automatic firearms can be banned by Illinois. They say it doesn't stand constitutional muster. They say pistol grips, forward grips, collapsible stocks, barrel shrouds, threaded barrel, changing magazine for more rounds, useful for self-defense, and is not a militaristic feature. They note that the state's expert, Colonel Tucker, said that changing magazines leaves you vulnerable. And plaintiff's expert witness, Watt, he said people are on their own in self-defense. Banned firearms are used for self-defense, the plaintiff said. They say such guns with features are ideal for self-defense, says no military in real-world issues across the world. They don't issue semi-automatic only rifles. Military spec requires burst or full auto. Even Colonel Tucker for the defense said don't prohibit burst or full auto from military. It goes on with some more of the plaintiff's arguments here. They lay out their ultimate final thoughts, saying features are commonly owned for lawful purposes and they train with defense in mind. Experts recognize the use of such for self-defense, and they also point to their first witness, Scott Pulaski, the owner of Piasaw Armory, who said only Illinois resident to testify, recommended that semi-automatic firearms for self-defense to his customers before they were ultimately banned. They say shotguns with detachable magazines and magazines with more than 4 rounds, five rounds, are common for self-defense, and they are set to provide a lengthy amount of documents to support all of this. And the court should find that the Protect Illinois Communities Act is unconstitutional and enter a permanent injunction against Illinois from enforcing. Then they end their closing. Now, I do want to take just a brief moment here to kind of elaborate a bit on, why they're talking about the difference between military firearms and civilian firearms. And that's because the Seventh Circuit Court of Appeals, on preliminary grounds, laid out that the state had a likelihood of succeeding on the merits of the case because they said that AR-15 rifles, for example, are too adjacent and too similar to what's used in the military. A lot of the testimony, if you look at the threads from throughout the week, really focused on differentiating between military firearms that are made to go burst or full auto versus civilian firearms that are semi-automatic only. Everything from the metallurgy to the materials and such. So they laid that out in some painstaking detail. So then you get into the state's closing arguments, and let's pull this up for you. Again, you can see this on X, where they said the key question was about the material difference between civilian and military weapons. Experts agree that military trains with M16 and M4 on semi-automatic. Other fact is being put in focus. Both have grips, adjustable stock, flash suppressors, etc., with high rate of fire to kill enemies. Features are same, except select fire switch. They quote the plaintiff's witness, Gunner Eby. They also quote Ronkanen, who was a plaintiff's witness from Remington, about innovations for AR rifles, but no change to make safer civilians being shot at, the defense said. They say plaintiffs admits both civilian and military fire the same ammunition. Other facts, they say Illinois law prohibits .50 caliber. They say that that's rarely sold and can hit target from a mile away. They say that the plaintiff's witness, Watts, keeps AR pistols out of traditional pistol training. They say that no one told us that they use these for duck hunting. They said that hearsay from Scott Pulaski about why people buy. And again, if you missed some of that from earlier in the week, Pulaski said that some of the documents that he has people fill out asks why you're buying these particular firearms, and nobody says they do it for unlawful reasons, and a lot of people say it's for self-defense, but they said that's hearsay. Ronkanen said demand increased after the federal ban. They also quote Gunner Eby, again a plaintiff's witness, saying that he prefers AR-15 for self-defense only because full auto isn't legal. Finally, the state says plaintiff's witness Watt didn't provide real evidence, just anecdotes from people who self-select for his Warriors Creed self-defense courses. So the state says semi-automatic guns aren't suitable for self-defense. They say it fits dangerous and unusual weapons and definition between what's good for civilians and police, and they ask for Judge Stephen McGlynn to uphold the law, and then they end their closing. All right, so now let's get into Judge Stephen McGlynn's comments here, which kind of made everybody take a step back for a moment. All right, you figure he would say, all right, appreciate everybody's time, take this under advisement, but instead he talked for probably about 10 or 15 minutes. And I'm just, again, this is not a full verbatim transcript. The transcript of the trial will come out from the federal court soon. This is just a preliminary rough review, a distillation of what was said. So McGlynn, he says it's an important case and expects filings on history and tradition. So, they didn't really go into the history and tradition during the live testimony. They really seemed to just focus on addressing the Seventh Circuit Court of Appeals issue about military and civilian firearms, as they claim were too adjacent. But I expect the filings in the next 30 days are really going to focus on that history and tradition, text history and tradition from the Bruin precedent out of the U.S. Supreme Court. But it goes on to say that when case started, McGlynn questioned where it'll go. He also questioned why it's in East St. Louis. He said sacred sites are all around East St. Louis. He says it's important to recognize people sustained losses in East St. Louis. On 8th Street, there was a hospital where he said he was born and his twin brother were born. And then he projects an image, and again, rough transcript. I thought I heard 1970. It's actually 1917. But looking south, it shows burned areas from a riot. A man's house was burned, he said, for being black. The sacred site. End of court parking lot was an old Broadway theater. Word got out, black families were hiding in there. That was burned down. Nobody escaped. During the course of riots, 100 black armed were shooting back at the rioters. And the rioters said that's not fair. They went to the National Guard to complain. The Guard then gave safe passage to those black victims across the Eads Bridge into St. Louis. Another area, McGlynn said, line of demarcation. He said he points to the picture, and there was an arrow pointing to a building in that picture from 1917, surrounded by debris. And he said the building that's being pointed to was the courtroom we all were sitting in at that time. He says to him, it looks like Vietnam. says everything that families owned were burned by the mob. More of what McGlynn said: all black houses were set on fire one by one as people escaped to other houses that were burned. One man beat in the head with an iron pipe with a noose around his neck, not long enough to be hanged, but they dragged him. At 4th and Broadway in East St. Louis, there's a fountain in a park. A St. Louis reporter saw a body in there with one guy being pulled to be hung, with people saying, "Pull for East St. Louis." The mob prevented ambulances from helping. They stopped streetcars and dragged blacks out and beat them. McGlynn continued talking about other areas where they found a body of a child being essentially cremated. Others hiding in homes nearby, frightened, and fire from house to house while their house was collapsing around them. People were horribly burned, and the community lost everything. McGlynn wonders. He wonders if they tried to make a stand. They were poorly armed, he said. Fleeing from the mob, jumping in the Mississippi, off the bridge for certain death. What if they had some of these weapons, he asked. Who knows? Then he discusses Tulsa, Oklahoma. Black neighborhoods there, very nice. 1921, same thing happened. Mob sets upon them, burned and killed. More recent, he points to Aurora, Colorado, where international gangsters, well armed, going door to door, attacking. That video out of Aurora recently was 30 days after police were called. He said that they were on their own. Maybe a kid was hiding under a bed asking, "Mom, are the bad guys gone?" He says this is all part of our history, going to confront evil people throughout our lives. He says going to be called for self-defense of the community and of the country, he also said. With respect to what we have here today, Second Amendment has nothing to say, some may say. She's too old, she's lost luster, maybe too senile. But he also encouraged people, the litigants and those in attendance, before leaving East St. Louis, stop by those sites. Never know what's going to happen to you in your life. That's why this case is important. He doesn't question the sincerity of the litigants on either side. And then he wrapped things up, said 30 days to submit briefs. We are adjourned. So clearly some really strong history shared from Stephen McGlynn to wrap up the case, and seeming to ask that question. What if these black victims of historic riots, not just in East St. Louis in 1917, but Tulsa, Oklahoma in 1921, and even in Springfield, Illinois, you had a race riot of 1908. What if these black victims were armed? Does that indicate how McGlynn will rule in this? Again, a question that is yet to be seen, but ultimately he will make his determination, and after 30 days, when they file the briefs back and forth, could he issue a permanent injunction on final judgment and then move that case ultimately up to the appeals court? And how quick will that happen? We heard earlier this week from attorney Thomas Magg for the Langley plaintiffs that he expects that to happen within 20 minutes. So we'll be watching this closely over the next 30 days to see what's filed about text history and tradition from both sides. We'll then obviously hear and read through what Judge McGlynn orders. Does he issue a permanent injunction halting enforcement of the law? How long would that permanent injunction last for? Again, questions that we have yet to get those answers to, and we could get those within 30 days. But some people looking at McGlynn's comments there as indication of how he may rule in this case. After last year, recall, McGlynn did issue that preliminary injunction against the law that lasted for 6 days before the appeals court took it up and reversed that, and then ruled in favor of the state. But clearly, now on the merits, this is final judgment that we're looking for. Then it'll go to the appeals court and then to the U.S. Supreme Court. However, you do have that Maryland ban that is likely in front of the U.S. Supreme Court well before Illinois' gun and magazine ban gets to that space. So a lot to be said about all of this. Again, it's Illinois in Focus Daily. I was in the courtroom all week long, back at the home studio here. So if you missed any of the proceedings that I posted on X, go to x.com/bishoponair, and you'll be able to check that out. All right, it is Bishop on Air here with Illinois in Focus daily, America's Talking Network, and the Center Square. Greatly appreciate you tuning in each and every weekday morning. We'll have another segment here and hear from attorney David Siegel for the Herald plaintiffs, sharing some of his thoughts about the final day of court action in the case challenging Illinois' gun and magazine ban. Stay tuned.